Judgment in the appeal, the Queen on the application of F and Thompson against the Secretary of State for the Home Department.
Under the Sexual Offences Act 2003, anyone in this country who is sentenced to more than 30 months imprisonment for a sex offence has to present himself to a police station to confirm his current address once a year to the day he dies. He also has to do the same every time he's about to travel abroad or to spend more than 7 days away from home. These notification requirements are an interference with his right to privacy under Article 8 of the European Convention on Human Rights, but they are a justified interference if they're a proportionate way of helping to prevent sex offenders from reoffending. 2 sex offenders have challenged these notification requirements on one ground alone. They say they are disproportionate because there's no right to have them reviewed. They contend that in some cases, offenders are in a position to demonstrate that there is no significant risk that they will reoffend. There's no justification for making such persons go on reporting to the police to the day they die. The Home Secretary has sought to defend the notification requirements on the ground that no review could with confidence identify those who pose no significant risk of reoffending. The Divisional Court and the Court of Appeal did not accept this argument, nor has the Supreme Court. Other jurisdictions have similar notification requirements for sex offenders, but most of these have provision for review. There are other situations in which our own jurisdiction requires review of the degree of risk posed by sex offenders. It may be appropriate to impose exacting requirements for lifting notification requirements. What is not compatible with human rights is to refuse in all cases ever to consider lifting them. Accordingly, the Court is confirming a declaration that the legislation is, for this reason, incompatible with the Human Rights Convention. And so it is declared that the indefinite notification requirements in Section 821 of the Sexual Offences Act 2003 are incompatible with Article 8 of the European Convention on Human Rights, insofar as they do not contain any provision for the review of the justification for continuing the requirements in individual cases. And it's ordered, first, that the appeal be dismissed, and the appellant, the Secretary of State for the Home Department, pay the reasonable costs of the first and second respondents, that the first and second interveners make written submissions on costs by the 5th of May, and that there be a detailed assessment of the first and second respondents' publicly funded costs under the Community Legal Services Cost Regulations 2000 and the Civil Legal Aid General Regulations.